Yes, we've had the police there numerous times, and Adult Protective Services is involved. He gets violent to where he wants to hit me. He's quote numerous times, and he won't bathe, he won't change his clothes, he won't shave, and
Does he take medication?
he was taking it until just recently, and he just came home with big bags of medication from Usry Rome. I don't know if they were prescribed. I don't know what. And he took them for a while and then he quit.
So he's not taking medication for anything at this point?
I think he has started taking some trazodone, and my daughter said she doesn't want him to take that because he acts up when he does that.
What do you know what that trazodone is for?
I have no idea.
Okay. Now, you talked earlier about him giving $20,000 to a woman. Did that happen since he's been home?
No, that was right before everything started.
Okay, so that was back
After Thanksgiving.
Okay, tell us about that incident, if you will.
Well, I went in and sat down one morning, and I heard him call the bank, and they told him, they said, "You can't do that, Mr. Martin. You're $20,000 overdrawn at the bank." And I just jumped in the car and ran to the bank because I didn't know what else to do. And what money we had, I put in my account only. And I did call Linda because I had heard him mention her name, and I got on his phone and found her number.
Now, Linda's who?
Linda Moore. She was the woman that he sent the $20,000 to.
And do you know why he sent $20,000 to her?
He was wanting her to buy Bitcoin. And he decided, rather than these people using their own money, he would send them money that they could buy Bitcoin and they could all get rich.
Well, did he purchase the Bitcoin?
No, she sent the money back to him.
So she sent it back to you.
Yes.
Okay, so now you've also talked about his obsession with buying vehicles. When you left my office on the day that we filed this application on March the 29th, what did you find when you got home?
I had found a 2020 red CTS 5 Cadillac sitting in my driveway.
Was it from Alderson Cadillac?
No, it was from Sewell Cadillac in Dallas.
And how did it get there?
I have no idea. A gentleman, I understand, brought it. He drove it to Lubbock and then he flew home.
Did your husband order that vehicle?
Yes, he did.
Okay. And how did he purchase it?
He purchased it with zero down, zero interest, and he has 6 years to pay for it. That's $700 a month.
Okay. So Cadillac's still at the house.
We are sitting downstairs right now.
Now, obvious based on your testimony that his behaviors have been very inappropriate. Are you concerned about his health and well-being going forward?
I am. Joe had large cell B lymphoma, I think is the way it was described, about 5 years ago. And our doctor told us that it would probably, there was a 50-50 chance that it would come back. And when it did, it would come back with a vengeance. And most likely it would come back in the brain. And we have asked the doctors, and since I can't make him do it, we have asked him to have brain scans. We have asked the VA to do brain scans. We've asked everybody to do that. And of course, my son's in the medical field, and so is my daughter. And we have gone to Dr. Maida, is his psychiatrist at the VA. And we have talked to her nurse. And we all believe at this point that he has what is called brain mets, which is a brain cancer. And we've all looked it up. And of course, Lynn at the VA says she believes it's the same thing. That's why he's becoming mellow and wanting to. We've always described Joe as very stingy and very tight. We've always described him as squeezing a nickel until the buffalo hollered, because he would give nothing away and he was so tight. And now he wants to give everybody money. He wants to give everything to everybody.
Sure.
And but we can't make him have a test to find out. He won't have the MRI. but we all feel like that he may have a type of brain cancer that he won't live very long.
And that's another reason why you need this guardianship.
Yes,
You
we
need
want
it
to get the
immediately.
test.
Fair to say that he's not, not only is he not taking care of his personal affairs such as his hygiene and making rational decisions, but do you believe he's unable to even make those?
I do.
Okay. You feel like a guardianship today, an emergency guardianship of his person only, now we're talking about person only, is in his best interest?
I do.
Okay. Do you know of any reason why you would be disqualified to be his guardian?
No, because I want his best interest.
And you were his guardian once before
I
in the
was.
recent past, is that correct?
Yes.
Okay. Now you've also made an allegation in your application asking the court, well, how long have y'all been married?
We've been married 48 years and we dated 2 years before we got married.
Your entire estate, we've talked about what community property is. You know what it is.
I do.
And would you allege that your entire estate consists of community property?
Yes, it does.
And are you asking the court to also appoint you today as the community administrator with the ability to be able to manage the entire community estate, to basically control it, to be able to protect it, to spend it as you need to for the benefit of both your husband and yourself?
Yes.
Okay. Judge, I think I'll pass the witness.
Okay, Mr. Norman.
Thank you, Judge. Mary, as you know, I've been appointed to represent Joe's interest in this. And so I've got a couple questions for you. You said that y'all been together for 50 years, correct?
Yes.
And during that time, have you gotten a pretty good idea of Joe's personality?
Yes.
During the last 6 years or so, you started to see his personality affected by some sort of mental disorder, correct?
Correct.
You were talking about earlier, brain mets, also known as metastatic brain cancer, correct?
Correct.
And that has been a recent, I guess, hypothesis by you and the doctors as far as what is affecting Joe. Is that correct?
Correct.
Okay, you'd spoken a little bit about his trazodone and how you've decided that you don't want him to take that. Is that correct?
Well, his attitude and his personality really changes when he has that. But it's something that we need to talk to the doctor about.
Has he been prescribed that medication?
He was when he was at the home, yes.
When you say at the home, you mean at your home or at a inpatient clinic?
I think it was when he was in Ussery. Right.
Okay, and the doctor has not stated that he should discontinue that, correct?
No, because right now he is not under a doctor's care because they just let him walk out. And we can't get the orders from Ussery Rome. The VA here cannot get the orders so that we can see what's going on. They handed him just a handful of medication in cards, and we don't know what it's for, and we don't know what it is. And Dr. Maida can't get the information until they send it up there, and we can't get Joe to sign an agreement to let us have it.
Do you have a medical power of attorney signed by Joe?
No, I do not.
Okay, and do you believe that he would be able to execute a medical power of attorney at his mental state?
I don't think he will, no.
Okay, you'd stated that he was served those guardianship papers by the sheriff sometime between filing and this hearing, correct?
Correct.
Do you recall his reaction when he saw those papers?
Yes, Regina and I were on the way to Amarillo to get his stuff in case he got really mad while we were gone. He had a TV and a refrigerator up there. And he called us on the phone and he said, I just got served by a sheriff wanting you to have guardianship. And he says, I just want you to know I tore them up and that's never going to happen.
Okay, so he is opposed to this guardianship, correct?
Yes, he is.
And in 2015, when you obtained guardianship, he was opposed to that as well, correct?
Correct.
Okay, and since 2015, we've had some kind of, I guess, legal proceedings that may have been, I said you disagreed with them, correct?
Correct.
The doctor stated that he should be restored, correct?
Yes.
And that is the last doctor's report that you have, is that he has capacity, correct?
Well, they're all saying he needs a bunch of tests done, but Joe won't have them done.
Okay. So the last time that he did do those tests, though, he had capacity, correct?
Yes. He had a Dr. McCorkle, and I don't know what kind of test he did, but he doesn't do the brain scan or any test like that. He does some kind of test on a paper, on a
Okay.
sheet of,
Some sort of mini mental exam, something along those lines?
I guess so. I don't know. He won't give us a copy of it either.
Okay. Is there any way that you could get Joe the medical care that he requires without a guardianship?
No,
Is he outright refusing to go to a guardian?
yes,
I'm sorry, not to a guardian, to a doctor?
yes.
Okay. And have you been trying to get him to go to a doctor for quite a while, or is this a recent refusal?
We've been trying to get him to go. He likes Dr. Maida at the VA. She's been his doctor for a year or so, and he really likes her, but he won't allow her to do these tests. I think that Joe really knows something is wrong. And Dr. Figueroa told us when this came back, it would be in the frontal lobe and he would be able to feel it.
Do you have an indication that Joe is feeling some sort of pain in his frontal lobe?
I do.
And what is that?
He's having headaches, memory loss. He can't remember how to work his phone. He can't remember names. He can't remember where he goes. When we get out in the car, he always wants to know where I'm going because he can't remember this is the direction we're supposed to be going.
And with no disrespect to 70-year-olds, is it common for them to have a hard time working their phone?
Joe is a brilliant man. He's an electrician. He's an electrical engineer. And there was never anything Joe couldn't work until all this started. And we were down in Rockport. He would try to take everybody's phone and he wiped mine clean because he had already screwed his up and then he screwed mine up. And then he started asking for the kids because he wanted to go buy cars over in Corpus. And nobody would let him have their phones.
So his inability to operate his phone is not simply, I guess, common for someone who is his age. It is recent that he is having those difficulties. Is that correct?
Correct. He wiped all of his contacts and all of mine out.
Okay. And are you asking to be appointed as community administrator today, or is that only upon permanent guardianship? And I guess that might be a question Bob could join in on.
We're asking for that appointment to occur today, Dane.
Okay, and Judge, I'll address that in my closing, but there might be an issue there.
Well, and I think I can answer that issue. So go ahead.
Okay, then I believe that's everything. I'll pass the witness.
All right.
Nothing
Mr.
further.
Jones, wish to follow up on anything?
Nothing further, Your Honor.
Okay, thank you. Mr. Norman, do you have any witnesses you wish to call?
I have no witnesses, Judge.
Okay, thank you. Close.
I do close.
All right. Mr. Jones, do you have any closing statements you wish to make?
Your Honor, I don't believe it's necessary. I believe you heard the evidence. I think it's overwhelming that there's a need for an emergency guardianship in this case. Obviously, he has not been examined yet for the purpose of converting it to a permanent, but we will do that as soon as she has the ability to be able to have him examined, which may be difficult in its own right, but we'll have all that done within the next 60 days.
Okay, thank you. Mr. Norman.
Judge, they have asked for a temporary guardianship of the person and the community administrator. Their application specifically states that it says applicant requests that on the court's finding of incapacity of the proposed ward, that Mary Jo Martin be appointed as the community administrator. A temporary guardianship has no finding of incapacity. That's why there is no CME that is required. I don't believe that we would be able to proceed with a community administrator on a temporary guardianship. If they wanted to look at a temporary guardian of the estate, then that would not require that finding of incapacity. I'll let you decide on whether the temporary guardianship of the person is warranted. My client objects to that, therefore I would object to that on his behalf and let you defer to the testimony. However, that community administrator, I don't see anything in the estates code that permits that to be done on a temporary basis. If there is concern about protecting the estate between now and a final hearing, then I would state the only option there would be a guardianship of the estate that could potentially be turned into a community administrator upon that finding of incapacity. But without a finding of incapacity that would require that CME, then I don't think that we can proceed with that.
Thank you, Mr. Norman. Ms. Wharf, I have read your report. Thank you very much. Based on what you've heard today, I know the issue with the community administrator that Mr. Norman has brought up. I've read through the statutes and some of the case law as well. Do you have any opinion as to going forward?
It's difficult because I agree with Mr. Norman that, I mean, clearly there's no finding of incapacity for a temporary guardianship. So, I mean, the evidence is pretty, as Mr. Jones said, overwhelming that, I mean, there likely is some incapacity. Of course, I was involved in the restoration of Mr. Martin when that was requested. And it just, for the record, and just so I can, I can just make it clear, the restoration was adamantly asked for by both Mr. and Mrs. Martin. They were both, I interviewed them both. They were both adamant that occurred. They are the ones that requested it. I'm nothing against Mr. Norman, but I'm a little bit disappointed that David Kirby wasn't appointed as the ad litem in this case, because he was the ad litem at that time and he did a thorough investigation as well. And so, I think he would just have, more insight into that as well, because he was involved. But, unfortunately, he's not involved. Like Mr. Norman pointed out, the only medical document that we have from that case is also adamant that Mr. Martin at that time had capacity. Obviously, things have changed, and obviously he has greatly declined since that restoration occurred. So, I certainly can't diagnose him. Nobody, I think, in this hearing can diagnose him. I think the facts are clear, though, that there is an issue. I have no doubt whatsoever that when his capacity is looked at, that he will be found to be incapacitated. But, I don't think we can make that. I don't think that you can make that ruling prematurely. So without that medical documentation, I have no concern with a temporary guardianship of the estate. If that's the solution, I wouldn't have any sort of recommendation for bond at this time, just because I don't know what the estate is, community, or, I just don't have any idea what they have in liquid assets. So,
Well, I suspect we're going this community route in order to avoid any kind of bonding.
Well, and I always support a community administration above a guardianship of the estate, because I do think that's a less restrictive alternative. So I certainly, if not now at the final hearing, I think that that's a wonderful solution. I do think it's just a matter of whether you can grant that now before there's medical documentation that he's incapacitated.
Judge, may I interject at this point when Ms. Wharf is finished?
No,
I think,
that's all.
yeah, I think she's done. All right.
Judge,
Go ahead, Bob.
just a little bit. I know where the court's going on this, and I don't disagree with it, although I think that the court, for purposes of a community administration, could determine based on the testimony that there is incapacity. I believe the court could do that. I have not looked at the case law on that. I don't disagree with Mr. Norman that incapacity needs to be found before community administration can be granted, but I believe the court can make that determination based upon the testimony today. But if the court does not feel comfortable in doing that, I would amend my pleadings to ask for a temporary guardianship today, and ask the court to grant that. But I would also ask the court at this point to set a minimum bond. She's going to have to post $100 bond anyway, and I'd ask the court to make that the bond going forward, and we'll do a temporary guardianship of the estate as well. And then when we get this converted, we'll have all the evidence necessary if the court does not feel it can make the determinant of incapacity based on the testimony. So that's my argument, Judge.
All right, thank you, Mr. Jones.
Judge, if I may, just regarding that restoration was in some ways forced by a ruling by Judge Head, in which he did a letter ruling stating somehow that it was a temporary guardianship that expired by operation of law. Therefore, that left Mr. Martin in limbo, where there's a previous finding of incapacity and then something that said it expired. So I believe Ms. Wharf was basically cleaning up what was somewhat of a mess. As far as, and it was supported, I certainly don't want that to somehow be, I guess, a sticking point here. But
No, it's not, Mr. Norman. In fact, I have reviewed the case file. I agree with you. I think it was just there was some cleaning up that needed to do. And in fact, I think for the purposes of a temporary guardianship, the question to the court is the immediacy of this. And so if I'm not even going to address a finding that happened 5 years ago. We're not even going to do that. We've got to look at the immediacy. All right. So that being said, Mr. Jones, I agree with you on many aspects of your arguments, simply because it is under a temporary guardianship. The court does find that there is a substantial amount of evidence that the proposed ward is incapacitated. That's a judgment of the court for this particular hearing. So it does trigger this incapacity. In fact, even under a temporary guardianship, the ward or the proposed ward, the person is deemed for this time period, for the 60-day time period, incapacitated as a matter of law. They are incapacitated, and all of the things that happen during an incapacity, the inability to vote, the inability to drive, the inability to make your own decisions as far as your residence, all of those things will apply during this 60-day period. So the finding of incapacity is based on substantial evidence. Now, the community administrator, the role of the community administrator says in 1353.002 is that when the spouse is judicially declared to be incapacitated. And that is essentially what we're doing here. Now, it doesn't say temporary, it doesn't say permanent, but this court is judicially declaring, or at least the procedure here is to judicially declare Mr. Martin incapacitated. So I'm comfortable that if we do this going forward to allowing Mrs. Martin to be the community administrator based on that. So that being said, let me just say that the court does find, hold on just a moment. The court, after considering the evidence, I'm sorry, go ahead.
I just point out 1251.002, a person for whom temporary guardian is appointed under this chapter may not be presumed to be incapacitated.
That's correct until the hearing. And then after the hearing, then if you look, Mr. Norman, at the order in 1251.01010 is that after the order is done, the court determines now that the applicant has established there is substantial evidence that the proposed ward is an incapacitated person, and it becomes
there a
part of the order.
Is there a judicial finding of incapacity though?
Yeah, the court determines. That's what it
Okay.
says in the law, that the court determines. In fact, if you look at the order itself, it'll say the court determines that this person is incapacitated. And in fact, and so what I'm going to say is that based on the evidence, based on the arguments of counsel, there is substantial evidence that the proposed ward is an incapacitated person, and that there is an imminent danger that the proposed ward's physical health and safety will be seriously impaired, and that the proposed ward's estate will be seriously damaged or dissipated unless immediate action is taken. And that's the crux of a temporary guardianship, is the immediacy. And the court is very comfortable that the applicant has made the case that there is some immediacy and an immediate need to care for her husband and to care for the property. The court specifically finds that the temporary guardianship is necessary for the following reasons: that there is a continued deterioration of the proposed ward's mental capacity. There is a need to protect the person of the proposed ward, and there is a need to protect the proposed ward's assets. Therefore, it is the order of the court that the applicant, Mary Jo Martin, is now hereby appointed temporary guardian of Joe Earl Martin. And the court further finds that the powers and duties to be exercised by the temporary guardian will include the powers enumerated in the order, including the duty of care and control of the ward, as well as the right to establish the ward's legal domicile. The temporary guardian will be required to apply to the court prior to exercising any power or authority not specifically provided in the order. I will require that the temporary guardian file a bond to secure performance in the amount of $100. This temporary guardianship will remain in effect for no more than 60 days. And therein kind of lies the real crux of this is temporary. Now, I know that they may want to go for a more permanent. We'll deal with that at that point, because then they'll have to go through all the examinations and the certificate of medical examinations, et cetera, Mr. Norman. But for a temporary purpose, I will go ahead and grant this temporary guardianship, including the granting of Mary Jo Martin as the manager of the community estate under section 1353.002 of the Texas Estates Code. Let's see. I do want to remind the ward that according to the administrative code, he is now hereby ineligible under Texas law to possess a firearm or ammunition. Now, as we've pointed out, this ineligibility will only last for the duration of his temporary guardianship. So when that temporary guardianship is dissolved, or if it is dissolved, then his rights to keep and bear a firearm will be reestablished to him, as well as the other rights and duties that he has as a citizen as well. That will be included in the order, and we'll just make sure that those things are relayed to the ward as well. Okay, is there anything further?
Nothing further, Your Honor. I do have an oath here from Ms. Martin to sign, and we'll execute that.
If you will do that. Yeah, if if you'll go ahead and get her to sign that oath, make sure it gets notarized and
Yes, sir.
upload that to the court's file. I will go ahead and sign this order. And then she will need to post that $100 bond.
Yes, sir.
Following that, then the clerk will issue those temporary guardianship orders. And Mrs. Martin, I really can't stress enough that this is temporary. Now, I
Yes,
know
sir.
at some point we may come back here and talk about wanting to make this a little bit more permanent. And then we will talk about the issues involved and whether it's warranted or not, or whether anything has changed. It sounds like with your husband's medical condition, who knows? Things can change. And so we will certainly deal with that in the appropriate time. But I think as for now, I'm very comfortable with granting you the temporary guardianship, letting you also be the community administrator to guard the assets of the community property. I think that's going to be very important for you specifically because they're your assets as well. And so I want to make sure that you're protecting your assets as well as your husband's as well. So best to you.
Thank you.
Okay, on a personal note, you know, we see a lot of guardianships here, and as you probably know, and Mr. Jones has been a part of these, Mr. Norman, Ms. Wharf. Every once in a while we'll come across ones that are truly heartbreaking, and this is one. I'm truly sorry for you, and I appreciate your heart in still wanting to care for your husband. That to me shows that you have valued your oath to him, the promise that you made to him in front of your family, in front of God, that you would love him in sickness and in health, and richer and poorer, for better or for worse. And I know that there was lots of betters, and there was lots of richers, and there was lots of health, but now there's not. And there's some worse. And your promise to him, your oath that you gave him is still intact. And I honor you for that. So thank you. Thank you for what you're doing. And may God bless you. And I know we'll see each other very soon.
Thank you.
All right. Is there anything further?
Nothing further, Your Honor. Thank you very much for your time.
Mr. Norman, I still would like you to stay on as ad litem, at least until we can get through the next 60 days and see what happens forthcoming.
Sounds like a plan.
Thank you. All right.